Hello, everybody. Good afternoon. My name is Jamie Tabb. I'm a partner in our government contracts group here at Vincent & Elkins. I'd like to welcome everyone to our presentation, U.S. Government Contracts Developments in the First Year of the Biden Administration. We're excited to share some updates and insights with you regarding what's been going on in the government contracts world. First, I'd like to introduce my co-panelists. To my right is Tyler Robinson. He's a counsel also in our government contracts group here in DC. And to my left is John Statira, an associate in our government contracts group who also works on CFIUS matters. Both of these guys are fabulous attorneys, and I work with them all the time, so I'm sure you'll be interested to hear their insights. Let's move to the next slide. So some of you may have tuned in last year. Some of us did a presentation around this time, I think it was May of 2021, focused on US government contracts developments during the first 100 days of the Biden administration. So we've crafted this presentation to be kind of an update to that prior presentation. And so we'll be focused on developments over the first year. Obviously, we're cheating a little bit. It's more like about a year and 5 months or so. But and I think you'll notice some common themes from the prior presentation we did, because many of the policy goals that were tackled during the first 100 days of the administration have carried over and have continued during the past year. So as you can see on the slide, we've divided the presentation into four main categories. We're first going to discuss the COVID-19 vaccine mandate that I know many of you were paying attention to, especially last year. We have a regulatory and statutory update. We're going to go through some enforcement initiatives. And finally, time permitting, we'll discuss some case law developments. We have some cases to highlight, both in the claims and disputes context and in the bid protest context. So can we go to the next slide, please? So this is actually our first survey. We wanted to get a sense for what you all are thinking about in terms of major policy areas that are impacting federal procurement. So the question is, which policy area impacting procurement should the Biden administration focus on the most? A, the COVID-19 pandemic. B, job creation, domestic manufacturing. C, wage and labor issues. D, climate change and environmental justice. Or E, something else. So you should be able to, I see the answers coming in already. We'll give you a minute to respond, and we'll continue with the presentation, and we'll take a break in about a minute to tell you what the answers were. So I'm going to turn it over to Tyler. We can move to the next slide. Next slide, please.
Thanks, Jamie. So COVID-19 has obviously been a powerful driver of events these past couple of years. So we wanted to start with something that likely impacted many of you on the CLE, and that's the federal contractor mandate. So just to recap with a bit of background on this, on September 9th, 2021, President Biden issued Executive Order 14042, ensuring adequate COVID safety protocols for federal contractors. And on September 24th, 2021, the Safer Federal Workforce Task Force, mouthful, issued its COVID-19 workplace safety guidance for federal contractors and subcontractors. And in that guidance, there were three main areas and requirements. And the first being the most significant, that all covered contractor employees were required to be fully vaccinated by December 8th, or the first day of a period of performance of a newly awarded contract. Now, what made it particularly expansive is the way the guidance defined covered contractor employees. Under the guidance, covered contractor employee were those employees working at a location controlled by the contractor at which a covered contract was performed, even if those employees themselves did not work on the covered contract. So in short, the rule required employers to make sure that employees who worked in any building at which any work was done on a covered contract to be fully vaccinated. Second requirement was a requirement to implement masking and physical distancing protocols. And the third was to designate a a specific individual or group of people who were tasked with implementing and coordinating compliance with the guidance. So according to the executive order and the guidance, the federal government was required to add a contract clause implementing these requirements into most prime contracts. And then prime contractors were required to flow down the clause and the requirements to their subcontractors, thereby further increasing the scope of the requirement. And as required, executive agencies did begin promulgating contract clauses, and they did begin incorporating the clause into contracts by bilateral modification. Next slide.
Tyler, before you get to your update, our poll results show that folks think that job creation and domestic manufacturing is the most important federal procurement initiative, followed far behind by wage and labor issues. Job creation was 47%, and wage and labor issues came in at 16%. So kind of interesting there. Sorry to interrupt.
No, thank you, Jeremy. So as we certainly know, compliance with these requirements caused a lot of concern among industry, and many companies devoted significant time and resources to devising compliance strategies to comply with these new contract clauses. And it's at the same time, while companies were doing that, numerous states filed lawsuits challenging the legality of the mandate. And there are currently 7 primary cases filed throughout the country, covering 26 states. And the cases generally, there's one in Florida, one in Texas, one in Arizona, a consolidated group of 10 states in Missouri, a consolidated group of 7 states in Georgia, consolidated groups of 3, both in Kentucky and Louisiana. In each of these cases, the state sought a preliminary injunction, and from November 2021 through January 2022, each of the district courts did enter a preliminary injunction enjoining the enforcement of the mandate while the cases proceeded. And there were some variants in the arguments across the cases, but the one legal theory consistently adopted by the district courts was that the plaintiffs were likely to succeed on the claim that the president had exceeded his authority under the Federal Property and Administrative Services Act in issuing the executive order mandating implementation of the vaccination requirement. Those preliminary injunctions varied in scope. Some of the preliminary injunctions were limited just to the boundaries of the plaintiff states, but 2 of them, the Georgia and Texas injunctions, granted nationwide injunctions, thereby enjoining enforcement in the other 24 states, even though those states hadn't filed a similar lawsuit challenging the mandate. As a result of those injunctions, the federal government paused implementation of the vaccination mandate, and the task force published on its website that the government will take no action to enforce the clause implementing requirements of the executive order, absent further notice from the agency where the place of performance identified in the contract is a U.S. state or outlying area subject to court order. So essentially, because the Georgia and Texas case, that's everywhere. Next slide. So the first question is, where are we now? And not surprisingly, the federal government has appealed all 7 of the preliminary injunctions, and there are currently appeals pending in the 5th, 6th, 8th, 9th, 10th, and 11th circuits. And for those of you sharp-eyed out there, that's 6 circuits for 7 cases, and that's because Georgia and Florida are both in the 11th circuit. The 11th circuit has paused the Florida case while the Georgia case proceeds. As of now, briefing's continuing, but there hasn't been much movement. The 2 notable developments are in its very first appeal relating to the decision in Kentucky. The government requested the 6th Circuit stay the injunction pending the appeal. But in January, the 6th Circuit denied the stay request, and that appeal is proceeding again with the injunction in place. The second development was not too long ago. On April 8th, the 11th Circuit was the first to hold oral arguments on these cases in relation to the Georgia appeal. Again, that was one of the nationwide injunctions, so the government challenged both the merits of the injunction and the nationwide scope. So the 11th Circuit decision is going to cover both of those topics when it gets issued. Briefing's continuing in the other cases, but as of now, We've checked the dockets and there are no other oral arguments scheduled as of yet. So next slide. So then the next question is, where are we going? As I mentioned earlier, as a result of the appeals, the government has continued to defer enforcing the vaccination mandate nationwide pending these decisions. So essentially, we're in a holding pattern. Realistically, though, this is going to probably will end up at the Supreme Court for a review of the question of whether the imposition of the mandate exceeds the president's authority under the Federal Property and Administrative Services Act, just like the Supreme Court reviewed OSHA's and CMS's rules. As a reminder, in those two statute-based cases, the courts split. In National Federation of Independent Business v. Department of Labor, the Supreme Court found that OSHA's vaccine or test mandate for employers with 100 or more employees exceeded OSHA's authority to establish safety standards for workplaces. But at the same time, the court found in Biden v. Missouri that the Centers for Medicare and Medicaid Services vaccination mandate was within the scope of CMS's authority over regulated healthcare providers. So given those two decisions, it's not clear now which way the court would rule on a decision on the Federal Property and Administrative Services Act. But generally speaking, it's always been thought that the president's authority under that act is very broad as to what terms can be included in federal contracts, which is why many of your contracts include numerous requirements that don't necessarily directly relate to the services or goods being provided. That means that as a result, if the Supreme Court decision limits the scope of the president's authority under the Procurement Act, that could be significant for reasons just beyond the imposition of vaccination mandate, because it could limit the executive branch's ability to implement other policy decisions through contract provisions. As many of you know, the federal government's first stop in implementing new policies is often creating a contract clause and implementing it through its contracts. But a Supreme Court decision narrowing the executive's authority to do so could lead to considerable litigation, both on clauses that are currently in government contracts and also restrict the ability of future administrations to implement new policies in those contracts. So these cases are significant both because of the vaccination mandate, but also because there could be much broader implications on government contracting. So definitely something that we're going to be paying attention to.
All right, can we move to the next slide, please? Thanks, Tyler. This is actually a good segue because, like Tyler was just talking about, a lot of the policy objectives that we're going to talk about in this next section of the presentation are exactly that, the administration using federal procurement to implement policy goals. But before we get to administration actions, we wanted to give you an update on one statutory development. This is called the Build America, Buy America Act. It was actually passed as part of the Infrastructure Investment and Jobs Act, otherwise known as the Bipartisan Infrastructure Law that you all read about in the news, passed last November. And generally, the statute authorizes appropriations for a variety of infrastructure projects involving highways, rail, energy, water infrastructure, even broadband. But we wanted to highlight this because we figure many of you your companies may be interested in pursuing state and local contracts that are funded through this infrastructure bill using federal dollars. And so the key provision here, which we have highlighted, is that for federal financial assistance programs for infrastructure, all iron, steel, manufactured products, and construction materials used in a project must be produced in the United States. So as you can see, it's a pretty broad requirement, applies to all four different categories of products. And there are waivers available for public interest if domestically manufactured products are not available in reasonable quantities of a sufficient quality. And there's also an unreasonable cost exemption built into the statute. basically, the way that exception works is that if the use of a domestic product would increase the cost of the overall project by more than 25%, then the project is able to use foreign manufactured products instead of the domestic product. And one interesting aspect of the statute that we have highlighted here is that it applies to all federally funded infrastructure projects, regardless of whether they're funded through this specific infrastructure bill. So there may have been other projects in the works outside of this infrastructure bill. These Buy American requirements will apply to those projects if they have anything to do with infrastructure. And the statute actually has a pretty broad definition of what an infrastructure project is. So what does it mean to be produced in the United States? Well, it's a different definition depending on the category of product that you're talking about. For iron and steel products, the definition basically is that all manufacturing must take place in the United States from the initial melting of the iron and steel all the way through the application of coatings. For manufactured products, which are basically is what it sounds like, any product that is assembled or created through a manufacturing process using a variety of components, the product itself must be manufactured in the United States, and then the cost of the U.S. components in that product must exceed 55% of the cost of all of the components in the products. And perhaps not coincidentally, that is the same test that's applied under the federal Buy American Act, which applies to federal procurements, which we'll talk about in a minute. So this April, the Office of Management and Budget, OMB, issued guidance to start implementing these Buy American provisions of the infrastructure bill. The guidance provides standards for the review of waiver requests, things like requiring publication of potential waivers in advance, or requesting public comment. There's a new office within the OMB called the Made in America office, and so waiver requests have to be flowed through that office for review. And then the guidance also included initial guidance on what are construction materials. And so that's a quick summary of Build America, Buy America. One other interesting piece of the statute is that it also amended the federal Buy American Act, which, as I said, applies to federal procurements, to create special rules for iron and steel products. There hadn't been a provision of the BAA previously that specifically addressed iron and steel. So, and basically, as you see at the bottom of the slide, it's the same test that's applied to the federally funded state and local projects under the infrastructure bill. Basically, all manufacturing processes from initial melting through the application of coatings must occur in the United States. All right, let me move to the next slide, please. Just see that a question came in. Any chance that the administration will allow things like commercially available off-the-shelf or COTS exemption, as well as the commercial IT exemption in the IIJA grant guidance for domestic preference compliance? So that's a great question. What that's referring to is under the federal Buy American Act, there are exceptions for things like the questioner asked. Commercially available off-the-shelf items don't have to comply with the cost of components test that we talked about. There's also a broad exemption for commercial information technology products. I haven't seen any evidence that the administration is considering similar exceptions to state and local contracts that are funded by the infrastructure bill. But that remains to be seen. The OMB guidance does include a pretty long list of potential exceptions that federal agencies could consider granting using the public interest authority that we talked about. So a lot of the examples they list are things like de minimis components, small dollar purchases, things like that. I don't think it lists the COTS exemption or the commercial IT exemption as potential public interest exemptions, but it remains to be seen. I think the OMB guidance was preliminary, so there's going to be more guidance forthcoming. So to be continued on that question. All right, continuing with the Buy American theme. This was one of the initial policy objectives of the administration. There was an executive order issued in January of 2021 that we talked about in our presentation last year, called Ensuring the Future is Made in All of America by All of America's Workers. And as you see here, the goal is to strengthen the impact of federal procurement preferences in the Buy American statute for products and construction materials that are domestically manufactured from substantially all domestic content. And so what happened is in March of this year, the FAR Council published its final rule implementing Section 8 of that January 2021 executive order. And for decades, the Buy American Act really, and the regulations in the FAR that implement the BAA had stayed the same. There hadn't been any changes, and the fact that we now have this final rule coming right after a earlier final rule in January of 2021 that implemented a Trump executive order is pretty significant. So these changes to the BAA are kind of coming rapid fire. And the most significant change in the new rule is that it calls for staggered increases to the domestic content requirements for products and construction materials to qualify as domestic under the Act. The current test is that 55%, and we mentioned this on the prior slide actually, 55% of the cost of the components must be domestic for the product to qualify as a domestic end product or a domestic construction material. Effective October of this year, that percentage is going to go up to 60%. And as you can see on the slide, in 2024, it'll jump up to 65. And then by 2029, we'll go up to 75%. So this is pretty significant when you consider that the test was at 50% for decades, really, since this law was passed in the 1930s. And I think this is interesting because it shows kind of a shared policy goal between the Trump administration and the Biden administration, which in pretty much all other areas, there's not much in common between the two administrations, but Buy American and increasing these preferences and strengthening the statute is a shared goal of both administrations. So one other interesting piece of this is that the rule introduces the concepts of critical component and critical item. These are components and items that are deemed critical to the U.S. supply chain. We don't know what they are yet. There's a separate rulemaking that's going to actually have a list of what these are and what the additional preference factor will be. So that's forthcoming. And what is interesting about this rule is it does not replace the cost of component test with a value added test, which we thought was the most interesting aspect of the original executive order from January of 2021. That executive order suggested that the FAR Council come up with a test to measure domestic content by the value that is added to the product through U.S.-based production or U.S. job supporting economic activity. It was unclear how the FAR Council was going to come up with that kind of a test, and as you can see, they didn't. They just stuck to the existing cost of components test, but decided to bump up the percentages. So a lot going on in the Buy American world. It's unclear, what impact this really have. As a lot of you know, the Buy American Act usually only applies to relatively small dollar procurements because there's another statute called the Trade Agreements Act that overlays the BAA and creates an exception and allows for purchases of products from a variety of other countries on higher dollar procurements. But nonetheless, some interesting developments in the BAA world. Question coming in here. Do the domestic requirements apply to energy used in the production? So good question. The answer is no. The Buy American requirements really apply only to the physical items that are used and that are part of the product that's being manufactured. So it's the end product itself, or if you're dealing with a construction project, it's the items that are being delivered to the construction site for incorporation into the public building or public work, as well as the components, the physical components that are used and incorporated into the products or construction materials. So the energy that's used during the manufacturing process is not required to comply with any kind of domestic preference. So we can move to the next slide, please.
So another area where we've seen some regulatory activity has been in the area of wages and labor. There are, this all kind of started with the early Biden administration executive order promising to increase the minimum wage for workers under federal contracts. So we saw that come through in April of 2021. And then later that year, in November of 2021, we saw the final rule published by the Department of Labor actually implementing the objectives from the executive order. So now that we have some final information on that, we can lay that out for you here. There are 4 specific types of contracts to which the increase in the minimum wage for federal government contract workers that they apply to. And those 4 areas are the procurement contracts for construction, contracts for services covered by the Service Contract Act, concessions contracts, and contracts related to federal property and offering of services to federal employees, their dependents, or the general public. And also they are, it's applicable to contracts in the United States as defined in the regulations, which includes not just the 50 states and the District of Columbia, but Puerto Rico and other US territories as well. Importantly, when this rule became effective on January 30th of this year, it applies to new contracts and solicitations after that date of January 30th. But the definition of new contracts includes extensions or renewals of existing contracts, as well as exercises of options on existing contracts. So if a contract was in place prior to January 30th and an option was exercised after January 30th, you'll have to keep an eye out for the implementation of and the rules related to an increase in the minimum wage. For the specific workers that could see a wage increase, the rule applies to all non-exempt workers under the Fair Labor Standards Act working on or in connection with one of the 4 types of covered contracts addressed earlier. There are certain exceptions, including for employees working in connection with a contract. Basically on a contract means that you're working directly on that contract. In connection with means you're doing work that is necessary to perform that contract. So if 20% or less of if less than 20% of a employee's work is in connection with one of the covered contracts, then it would qualify for an exemption from this rule. And there are also different rules for tipped employees. There is a process being undertaken to eventually bring tipped employees up to the minimum wage requirements, but that is a bit longer and drawn out with its own special rules at this time. Also, to keep in mind, the final rule gives the Department of Labor the ability to increase the minimum wage annually, starting on January 1st, 2023. So this increase to $15 per hour might not be the end of the minimum wage increase, and it'll be important to keep an eye out come January. And then, of course, the one thing you can take away from this slide is look for FAR Clause 52.222-55. If you see that in a contract, that is going to explicitly incorporate these minimum wage increases. And Please note that this clause is also required to be flowed down to applicable subcontracts. Next slide, please. Also in the wage and labor space, there is a regulatory initiative for the regulations implementing the Davis-Bacon Act. Right now, the Department of Labor in March of this year issued a notice of proposed rulemaking calling for what has been described as sweeping revisions to these DBA regulations. Quick intro on the Davis-Bacon Act. It requires federal government construction contractors on covered public works projects to pay what is called a prevailing wage, which is a rate determined by the Department of Labor for local areas throughout the country to certain workers, specifically laborers and mechanics that are performing certain work. This affects a lot of workers. The Department of Labor has anticipated it affects 1.2 million construction workers and impacts $217 billion in federal construction spending annually. So some of the major highlights from the proposed changes include a change to the methodology to determine the prevailing wage. For a long time, for the past 40 years, it used to require surveys that if there was 50% of workers reporting a certain wage, that would be the prevailing wage. That is no longer proposed to be 50%. It's proposed to be brought down to 30%. So what that practically would mean is that it takes kind of less of a number of people receiving a higher wage for that higher wage to then become the prevailing wage. So this has the potential to raise up what the prevailing wage could be set at. And just also note, if there is no wage that hits that 30% threshold, then the weighted average of the reported wages would be used to set the prevailing wage. There are other mechanisms that are proposed that could result in more frequent updates to the prevailing wage. So for example, the prevailing wage could be set using the adoption of state and local authority wage determinations, which if done more frequently than the federal prevailing wage would be something that could be relied on for setting the prevailing wage. And these Davis-Bacon Act contract clauses have been proposed to be effective by operation of law, meaning that if the clauses are omitted from a contract, that doesn't mean that they won't apply to a contract. So should this proposed rulemaking go through as proposed, these clauses and requirements would be a part of all applicable contracts, whether explicitly included or not. And there, from a enforcement perspective, there are proposed anti-retaliation provisions to be added that would allow the Department of Labor to direct contractors to provide relief to employees who are retaliated against for reporting Davis-Bacon Act violations. Previously, debarment or suspension from federal contracting was the Department of Labor's traditional mechanism for enforcing anti-retaliation, but these new provisions could add to that. And so these are, there have been signs that these are controversial revisions. The Department of Labor received over 37,000 comments by the deadline. Some of the comments discussing how these regulations stray from the meaning under the statute itself. So, and note that this is only at the proposed rulemaking stage. So there is there hasn't even been a proposed or final rule issued yet. And so we could see a variety of litigation or challenges to these regulations. Next slide, please. Next slide, please. Oh, sorry.
No, this is it.
My bad.
Good. All right. Quickly switching topics, another regulatory update. You may be aware that one of the other policy goals of the administration is to tackle climate change. Back in January of 2021, there was an executive order, a very broad executive order laying out goals and requiring federal agencies to prepare climate action plans. And we mentioned in last year's presentation that there had been press reports about an upcoming executive order relating to climate-related financial risk. That did come out in late May of last year. And you can see there it expresses the administration's policy to advance consistent, clear, intelligible, comparable, and accurate disclosure of climate-related financial risk and to mitigate that risk and its drivers, and achieve the administration's target of a net zero emissions economy by no later than 2050. So most significant to federal contractors is Section 5B of the executive order, which directs the FAR Council to consider amending the FAR to require contractors to publicly disclose greenhouse gas emissions and climate-related financial risk and to set science-based reduction targets. And second, to ensure that major federal agency procurements minimize the risk of climate change, including requiring the social cost of greenhouse gas emissions to be considered in procurement decisions, and where appropriate and feasible, give preference to bids and proposals from suppliers with a lower social cost of greenhouse gas emissions. So some pretty substantial changes if they are actually implemented. The potential requirement for contractors to disclose greenhouse gas emissions is interesting. I'm sure all of you heard about the SEC's proposed rule, which would require publicly listed companies to have a similar disclosure requirement. So this would be possibly imposing that same or a similar requirement on federal contractors. There's evidence that the FAR Council is considering this. There are 2 open rulemaking proceedings, one for each of those subsections in Section 5B of the order. Unclear at this point what the proposed rule might look like, especially on subsection 2 relating to incorporating climate and emissions considerations in procurement decisions themselves. It'll be interesting to see whether that is rolled out kind of more as a responsibility criterion or actually as part of the evaluation criteria, akin to something like past performance. So we'll have to see what the proposed rules look like when they come out. There are disclosure related items in the FAR currently in subpart 23.8, but those are pretty weak at the moment. All they require is contractors to disclose whether they already publicly disclose their emissions and to provide the website where those disclosures are listed. Next slide, please. And some additional developments on the climate front. More recently, in December of last year, there was yet another executive order called Catalyzing Clean Energy Industries and Jobs Through Federal Sustainability. Basically, the idea of this executive order is to use the federal government to and procurement initiatives to promote the administration's clean energy agenda. You can see there are various sections impacting federal procurement. There's policies about purchasing environmentally friendly products, which basically means anything recycled or that can be reused. Pursuing procurement strategies to reduce emissions. There's a section that asks the General Services Administration to track any disclosures that end up being required pursuant to the prior executive order that we just talked about. And then there's section 303 called Buy Clean, which creates or requires the creation of a task force to consider embodied emissions and pollutants of construction materials in procurement decisions. So this executive order is also the subject of a pending rulemaking proceeding by the FAR Council. So again, yet to see kind of what the proposed rule will look like. But we do know it's going to involve a reorganization of FAR Part 23, which is the part of the FAR that houses the environmental provisions that are currently in effect. And so there has been some implementation of this executive order already. In February of this year, the Buy Clean Task Force was formed and assembled. And there you can see their mission listed on the slide, basically to develop recommendations on identifying materials such as steel and concrete, as well as pollutants to prioritize for consideration in procurement, increasing transparency of embodied emissions through supplier reporting, incentives, and technical assistance, and launching pilot programs to boost federal procurement of clean construction materials. we don't have this on the slide, but there's even this week, there have been further developments. Some of you may have seen in the news that the administration on Monday announced several solar energy initiatives. And two of those actually impact federal procurement. There was a discussion of creating master supply agreements for domestically manufactured solar systems that would allow for expedited procurement of domestic solar systems by the government, as well as this new idea of super preferences to apply the domestic content standards for federal procurement of solar systems. So you see there kind of the intersection of the Buy American policy with the climate change policy being implemented. So some interesting stuff. A lot of it is just pending, like I said, so we'll have to see what a lot of these rules end up looking like. Next slide, please.
So our next poll question for everyone, now that we've touched on three of the main regulatory areas the Biden administration has undertaken work in, our question is, which recent regulatory focus of the Biden administration will have the most impact on federal contracting? Updates to Buy American / domestic preferences, changes to the minimum and prevailing wages, and new climate change initiatives. So we will let everyone answer that question as we continue on to the next slide, please.
All right, one other notable development for federal contractors, and I'll go over this quickly, but for DoD procurements, there is a new final rule finally implementing a statutory provision from the NDAA for fiscal year 2018 for enhanced debriefings. And as many of you know, a debriefing is basically a meeting or a written summary of what happened during a procurement that is provided to the offerers typically after the procurement. And basically there are two parts to this. One part which has already been implemented, which previously was implemented through a class deviation, which allows offerors to ask follow-up questions to the government within 2 days of receiving the debriefing, and extends the deadline for filing a protest and triggering an automatic stay of performance until those questions are answered in writing by the agency. That had already been implemented. The new piece that had yet to be implemented, but is now in the DoD FAR supplement, is the opportunity to obtain a redacted version of the source selection decision document as part of the debriefing. You can see that that redacted SSDD will be available to small businesses and non-traditional defense contractors if the procurement is between 10 million and 100 million. And if the contract award is in excess of 100 million, any contractor that participated in the procurement can request a copy of the SSDD. So we can go to the next slide.
So quickly on continuing with the DoD trend, the DoD did recently release a guidance to contracting officers on inflation. And so kind of two major areas they focused on. First, for existing contracts, for cost reimbursement type contracts, the guidance basically stated that it was up to the contractors to notify contracting officers if inflation was causing costs incurred to approach limits that are specified in the contract. And then from that point on, it's on the government to determine whether to increase contract funding because the contractor is not obligated to continue performance beyond those funding limitations, which could occur more quickly than originally anticipated due to inflation. So some flexibility on cost reimbursement type contracts. Unfortunately, for firm fixed price contracts, the guidance was not as perhaps helpful from a contractor perspective because it noted that there really is no way to get relief for inflation in a firm fixed price contract unless there was an equitable adjustment, or excuse me, there was a economic price adjustment clause in that contract. And so the second part of the guidance beyond existing contracts was contracts being negotiated at a time of high inflation. And DoD guidance stated that encouraged contractors to and contracting officers to consider economic price adjustment clauses for contracts being negotiated now and to consider the equity of entering into those. And so before we move on, just update on the results from our second poll question. Pretty evenly split among the three categories. 41% believed updates to the Buy American and domestic preferences were the area that would most impact federal contracting, with the other two coming in close at around 30% each. Next slide, please. So last on the DoD trend, there was the passage of the National Defense Authorization Act for fiscal year 2022. Some key highlights we can run through quickly here. There was a lot of focus on cybersecurity initiatives. And so some primary things that you can see them listed on the slide, but some primary ones would be Congress asking DoD to reevaluate its controlled unclassified information program, which is a program that standardizes the handling of government information that is sensitive, even though it's unclassified, as well as seeking a report on plans for the Cybersecurity Maturity Model Certification Program, which has been undergoing development and implementation over the past couple of years. There's also encouragement in certain areas like artificial intelligence, machine learning, and other innovative technologies. So there may be some more appropriations coming down that pike. There is the promotion of or provisions for the promotion of non-traditional procurement methods, including other transaction authorities, which are more flexible arrangements contractors can enter into with the government that avoid the regulations under the FAR. And there are some other changes as well, like the repeal of the fixed price contract preference and requiring annual reports on domestic preference violations to actually name contractors. Next slide, please. And then to crystal ball for just a couple seconds here, the Biden administration had released its fiscal year 2023 budget proposal. And so some of the areas that we wanted to point out that could see an increase in appropriations and thus government contracting if this budget remains largely unchanged, include areas focused on supporting United States leadership abroad, specifically to counter Russian aggression. The typical focuses on U.S. infrastructure and U.S. supply chains. Of course, the continuing concern about future pandemics, so potential increase in public health initiatives. As mentioned earlier multiple times, focus on clean energy and fighting climate change. Interestingly, the Biden administration also referenced law enforcement, but with a focus on kind of what a Biden administration's focus on law enforcement would look like. So think equitable law enforcement initiatives like the purchasing and use of things like body cameras and changes in that area as well. And then outside of appropriations for that could affect contracts, there's also proposed increases to enforcement of antitrust law, which seems to be the major area of enforcement funding increase in the proposed budget. Next slide, please.
So thanks, John. That provides a nice transition to our next topic, the administration's enforcement initiatives. And just to start out with some overarching highlights, I want to highlight that we are in an era of increased antitrust scrutiny and very aggressive antitrust enforcement. There's an increasing DOJ focus on prosecuting individuals for antitrust crimes, and they are starting to focus much more on procurement and labor areas. And to give a high-level overview of why that's significant, it's because antitrust violations carry very stiff penalties. Individuals can face maximum prison sentences of up to 10 years and $1 million fine, and companies can face a maximum fine of $100 million or 2 times the gain or loss caused by the conduct, which can actually exceed $100 million. While DOJ is currently looking for quote-unquote hardcore antitrust violations, it is starting to scrutinize teaming agreements and other collaborations between companies to ensure they don't reduce or stifle competition. And this obviously includes looking in the government contract space, which brings us to the Procurement Collusion Strike Force, which was established in 2019 to combat antitrust crimes and related schemes of government procurement and grants at all levels, federal, state, and local. It's led by the DOJ Antitrust Division, but it is other offices and agencies do participate, including 22 U.S. attorneys' offices, the FBI, and numerous offices of Inspector General for federal agencies. The strike force has 2 main objectives. The first is to educate thousands of contracting officers and other government personnel to spot red flags of collusion and to encourage reporting suspicious behavior to DOJ. Thinking here is contracting officers have the boots on the ground, the front line. They have the most visibility into procurement, so they're the ones who will see and potentially notice issues first. Second, the strike force is going to detect and prosecute collusive conduct in procurement to protect taxpayer money. According to the strike force, 40% of federal discretionary spending goes to contracts for goods and services, which means more than $500 billion is spent annually on procurement. And the strike force thinks that up to 20% of discretionary government spending may be impacted by collusion. So while it's interested in all areas of government contracts, it has indicated it's particularly focused on small business set-aside fraud, infrastructure, COVID and disaster spending, and international spending. And the strike force has started to ramp up its prosecutions. There's just a couple of quick examples. In a case in Belgium, the strike force pursued an alleged conspiracy to rig bids, fix prices, and allocate customers for defense-related security services at contracts for DoD and NATO facilities in Belgium. Belgian company pled guilty, had agreed to pay a $15 million fine, and 3 individuals have been indicted, and so far 2 have pled guilty and are cooperating with DOJ. Quick federal example, just last month, a military contractor was indicted by a grand jury in Texas for rigging bids on military contracts. The allegation is the defendant and the co-conspirators rigged bids on at least 8 contracts and received more than $15 million from the U.S. government for work performed at the Red River Army Depot in Texas, the U.S. Army Contracting Command in Michigan, and Sierra Army Depot in California. 2 quick examples in the state infrastructure sphere. Former contract manager in California Department of Transportation pled guilty to bid rigging of California improvement and repair contracts. And a Minnesota company and its CEO were indicted for rigging bids for repair and construction projects in Minnesota. So obviously increased enforcement in this area, but the most relevant perhaps to the participants here today are the strike force's comments on teaming agreements. To be clear, teaming agreements are not illegal, but the procurement strike force has stated that they are taking hard looks at teaming agreements that appear to reduce competition. So what they're looking for are teaming agreements specifically entered into to reduce or eliminate competition, rather than just to fill out a bid team and provide necessary expertise, which actually increases competition. So using terms like taking them off the street definitely increases the risk that your agreement is going to be scrutinized. And given the increase of focus in this area, we highly recommend and strongly encourage you to assess and update your antitrust compliance policies, implement training of the procurement teams to detect and identify these issues far before they become federal crimes. Next slide, please. So the last area of antitrust enforcement that kind of bears mentioning here in the government contract sphere is the no-poach enforcement. 2016, DOJ and FTC jointly announced that they were going to prosecute no-poach agreements. A no-poach agreement essentially is an agreement between employers that otherwise would compete for employees where they agree to not solicit, recruit, cold call, and or hire another's employees. This is potentially very significant in the government contract space because frequent turnover of personnel and sometimes even workforces on services contracts, particularly in areas where there's a very limited pool of potential employees, such as classified work or specialized services. And as one example of why this is important to pay attention to, it is also given a civil cause of action to employees, and there's currently a prominent class action lawsuit against 3 prominent government contractors, CACI, Booz Allen, and Mission Essential, with the allegation being that the 3 contractors entered into an illegal agreement not to recruit or hire one another's employees working on contracts to provide intelligence services at a Royal Air Force base in Molesworth, England. So again, this is an area that DOJ is focused on a lot. So companies definitely need to ensure that your compliance policies and your communications with competitors around employees are up to speed. Next slide. Finally, we want to highlight the COVID-19 Fraud Enforcement Task Force. Shortly after our presentation last year, the Attorney General announced the creation of a specific task force to go after any fraud in COVID-19 spending. Like the Strike Force Task Force includes partners across agencies in the federal government and is aggressively pursuing criminal cases. A couple months ago, they just appointed a director to head this effort. So they are focusing a lot on this area. And while the primary focus at this time are the loan programs, payment protection, Main Street lending, economic injury disaster loans, and a lot of the fraud that you see the statistics for up there are the low-level simplistic schemes. This is going to translate into more scrutiny of federal contracts for COVID-19 response services and products. So that's likely going to involve increased false claims activity for pandemic-related programs. So anyone out there who's gotten a contract or a grant related to COVID-19 measures or responses should ensure that the paperwork is all up to order. And I know we're running out of time. Next slide. Our last poll question.
Yeah, actually, Tyler, we made the poll question live a few minutes ago to make sure we got it in before the. So if you haven't already answered, feel free to enter your response to the poll. But looks like we have some results already.
And it does look like procurement collusion does seem to be the one that's on the top of your radar. So again, I think that's right. As John noted, the budget focuses on DOJ's antitrust efforts, and we are seeing a lot more activity in this space.
So it looks like we're right about an hour. We we had a fear that we were going to have too much material, and so I think we'll have to save the case law developments for another day. But we hope this was informative for everybody. Thank you all for tuning in, and especially to those who submitted questions. To answer the question that came in, the slides are going to be available after the presentation, so we'll get those out to everybody. And feel free to contact any of the three of us if you have any questions that you think of after the presentation. Our information is on the website, and we'd be happy to chat with any of you. So thanks so much. Have a good afternoon.